Good morning. Today on Spotlight, an in-depth conversation with Michael J. Talbot. After 40 years on the bench, he recently retired as Chief Judge of the Michigan Court of Appeals. His list of judicial accomplishments and high-profile legal assignments reads like a who's who of law. Today, he'll look back on his career and he'll look ahead at what's next. It's Sunday, July the 8th. I'm Chuck Stokes, and this is Spotlight. All right, quick question. What does the J stand for?
Michael Joseph.
Okay, all right.
Every Irish Catholic family's got a Joseph, and there's probably a Michael somewhere there too. So, and a Patrick. My brother was Patrick. So.
All right, very good. 40 years on the bench.
Yeah.
As you reflect back now that you've moved into retirement, what sticks with you the most?
The specific opportunities, tasks that I was asked to do, and the opportunity to do them, and then hopefully they came out well. The time that you wish there are cases that you could do again, that you wish you would maybe come at it a little differently, tried it a little differently. So but you can't. There's some regrets, is really what I'm saying. I wish I could have done that differently again. But as a general proposition, the opportunities rather than the regrets.
How much do judges grow during that time on the bench? I mean, when you come in, are you a whole lot smarter by the time you walk off?
Well, I was a whole lot smarter in my head when I started.
Right.
And I'll tell you a story with that, because I had been in front of a circuit judge, Neil Fitzgerald, and then just a couple weeks before my appointment to the Common Pleas Court. That was my entry level. In 1978, I was appointed. Fitzgerald became ill. They called me within a month, I think. Would you go over on a Friday to take his motion call? And I said, sure. So I'm sitting in his chair, having been in front of the guy a month ago, and he was a tough guy. And all these lawyers are looking and they say, who's this guy? Well, I'm knocking him off and restoring some driver's licenses and just having a lot of fun. And feeling pretty cocky as a result. So I put my foot on the base of his chair and leaned back. That doggone thing flipped on me, and I'm on my back, and my feet are up in the air, and the clerk had to prop me back up. I still tell that story, and I remind myself of that.
That humbles you.
That does indeed.
You did a lot while you were on the bench. You reformed 36th District Court.
I thought it was a money problem. I mean, and there was one. And that, I think, was probably what first got the emergency manager to call the governor and say, I have to fund that court. They're spending $4 or $5 million a year over budget consistently. I'm not going to do that, and I need your help, Governor. And the governor calls the Chief Justice. Chief Justice called me. Now, that's the short version. When I went in, I thought it was money. But the more I looked at it, there were almost no pieces of it that were functioning, so that it became sort of overwhelming for me. I wasn't sure how to do this, and your name is now on the door, or however, in a literal sort of way. What do I do? Well, we had some great staffers, and I won't go into all of it. We can talk about it if you'd like. Happy to do it. But the point was that I found that I could identify, let's say, 3 things. And once you stay on those 3, if you pick the right 3, everything else can start to fall into place. So, of course, the one was the money, and the second was getting right-sized, and the third was advancing technology. 36th District Court, the Court of Claims. Which one was tougher to reform? 36th District is the second largest court in the state, and one of the highest volume courts in the country. So that, by far, I had 31 judges.
Just by sheer volume.
Plus six magistrates and a huge staff. So by sheer volume, and all the pieces had over time put layers and layers and layers, so that folks didn't even really have a good sense of how to reform things. Court of Claims was a court of limited number of cases that was given to us. It was a trial court, and I'll explain that. It's lawsuits against the state. And the state took it from Ingham Circuit and gave it to the Court of Appeals. We're the only intermediate appellate court in the country that has a trial court attached to it. But that's establishing something out of whole cloth, establishing a trial court within your court. So I was able to do that. I know how to do that. Wasn't easy necessarily, but I could do that easier than I could trying to reform this huge court that I went down in Detroit.
All right, we're going to take a little break. When we come back, I want to talk to you about what you did to champion victims' rights.
Okay.
We'll be right back. Stay with us. Judge, you were a trial attorney, then you became a judge. Did you enjoy one role more than the other?
There's no perfect job.
Because there's some lawyers who love being lawyers,
yeah.
being advocates, and there's some judges who love being judge, and then there's some who enjoy both.
As a trial judge, you're worrying about how to pay the office expenses, and you're worried about paying yourself and all that. So that's the negative. The fun part was that I was a trial lawyer. So I was in the pit and trying cases, especially criminal cases. So it's a fast track, and I enjoyed that. And I enjoyed the advocacy. Then there was a trial judge. And trial judge, you put pressures on yourself because you are trying to move cases along. So you're saying to someone, be here at 8:30, so you got to be there at 8:30. Mm-hmm. You got another case waiting in the wings, even as you're disposing of something in front of you. You've got all of that going on, so there's a lot of stresses that you, in effect, give to yourself. But at least you're in the action. There's a lot going on. Then you go to the appellate court, and the phone doesn't even ring. I mean, it is monastic. But you have time to think through a problem. You have time to reflect and write on the problem. So that, you see what I'm saying? That each one of these has its pluses and the drawbacks.
And its minuses as well. Justice Robert Young, retired now from the Michigan Supreme Court, when asked about you, he said, quote, "He is an extraordinarily talented jurist, and unlike most judges, he has superior administrative abilities." End of quote. Now that can be interpreted a lot of ways. How do you interpret that? Because some other judges, not you, may feel as though that's a slam on them. By the same token, it's obviously a compliment to you.
I don't take it as a slam. I hope nobody does. Not everybody is good, let's say, at even the case management of their own docket. And they should rely on their clerk to do that. And then do what you're good at in terms of the trial or whatever it might be. I have management skills, and that's not a false modesty. I know that I have those. And so not everybody has those talents. Mm-hmm. Others are better scholars and write better than I do. So everybody's got their gifts.
You could be a great judge, but not be good at managing a bunch of other judges.
Of course, and that recently I just gave a talk to the court of managers around the state, and no judges were present. And I said to them, among other things, the training to become the chief judge of a court is nil, to speak really as a practical matter. Because someone wants the job doesn't mean they should have it, number one. And number two, that when you do give it to them, and the Supreme Court makes all the appointments, you need to ask yourself, what do we need to give that person in terms of training and backup to help them function? Just because we picked a judge doesn't mean the job could be done well.
You were a champion for victims' rights. Mm-hmm. Why?
Well, I had practiced, as I mentioned to you, and I had practiced in doing criminal cases. And so I was aware of the process. There was a marvelous man named Bill Van Regenmorter in his first term as a state representative, non-lawyer, mm-hmm. Who drafted a bill for victims' rights back when nobody talked about this. So it'd be maybe 1970, in the later 70s, 78, 79. But it was not a very well-written bill. Called him, went up there. We spent a day at the state bar headquarters along with some staff and working this thing through so that we had a bill that would pass. And today we take so much of it for granted, but back then the victim had no status whatsoever in a courtroom. The victim was probably excused and sequestered almost throughout the trial, even after they gave testimony, with no good reason for it. The victim had no right of giving an impact statement as to how the crime impacted their lives and put into the pre-sentence report. The victim had no right to speak at sentencing, and I remember well, even after the legislation went through, judges saying, don't tell me how to run my courtroom. I don't need to hear from you. This is between me and the defendant. I remember teaching police officers, the chiefs and the bosses, make sure that the name and address, the name is fine, but the address is out. That has to be blacked out so that there isn't this harassment that has been taking place over the years. All of that cultural change we take for granted today, but I assure you back in the 70s, it wasn't there at all. There was a complete insensitivity to the right of a victim. And so we victimized them again when they came to a courtroom.
All right, we're going to take another break.
Okay.
Come back, I want to talk about your work with the Archdiocese of Detroit.
Sure.
And, of course, that pre-sexual scandal that you had to ride herd over.
Sure.
We'll be right back. Stay with us. You got appointed by which governors?
I was appointed to 2 different courts by Governor Milliken and to 2 additional courts by Governor Engler.
All right. They were very different personalities.
Oh, aren't they?
Both of the same political party, both staunch Republicans.
Yeah.
How did you see them?
Governor Milliken I didn't know as well as Governor Engler, but every relationship I had with him and just in observing him, he was and is just a beautiful, nice man who cares. And that
Often
caring,
described as a true gentleman.
Well, he's a true gentleman, and the caring comes across. And so he's putting that caring to work. And that's not to take anything from Governor Engler, but Governor Engler is the boss, and he's a leader. And his times were much
bull
tougher.
in the china shop.
And his times were much tougher in many ways. So he was the right man for that job. He was a true leader, and he could bring people together and say, this is how we're going to get it done.
Did you ever imagine he'd be in the position he's in today at Michigan State University?
I didn't
taking
imagine
that
it, neither
assignment?
did he,
Yeah.
I'm sure. And must be awful tough for him. You and I touched on this when we went during the break, and how he's used to a different, first of all, as governor, he's decided, and he had immunity, of course, and there was no FOIA discoveries, Freedom of Information discovery from the governor's office. But then he was in private enterprise, so he was not used to going into something where almost everything you think, let alone everything we know that you write or speak, is going to be second guessed.
Yeah.
So it's tough.
There's a learning curve.
Ooh, it must be very tough.
You're on the board of Sacred Heart. You've been an advisor to the Archdiocese of Detroit, now to the Archdiocese of Saginaw. You were involved with the pre-sexual scandal, overseeing that. Let's start with the pre-sexual scandal. What did you learn from that, and what do you hope the church learned from that?
There's a number of things that you do learn. The first of which is that I think I understand, didn't approve, but I understood that when they found that there was a priest with baggage of that nature, not necessarily of sexual conduct, but let's say just even boundary issues, they would just try to cover it up, move him on. They even had advice. They would send someone off, be evaluated, maybe treated for a period of time. And the advice then from these experts, who held themselves out as experts, psychologists, psychiatrists, was that we can fix these things, and therefore this person can go back into ministry. There's a debate now whether that's just nonsense or not. I mean, but that isn't even the question. It was again an absence of appreciation for the victim. The victim was not in the equation whatsoever, and that was maybe the greatest sadness of the whole thing, or at least equal to the moving of them along. That can't. The popes have spoken on it, and they've in effect said one offense is one too many, and you have to be out of ministry. That's as it has to be. It's very sad, but it is appropriate for these types of offenses.
You think the church has learned this lesson?
No, well, certainly some have. But I think there will always be a necessity for the lay people that are members of the faith to actively have a role in all of this. It keeps everybody focused appropriately and keeps everybody honest.
What are you doing for the Archdiocese of Saginaw now?
Well, Saginaw had a priest arrested for 2 cases. Mm-hmm. And I don't know much about the cases other than what I've read. And there been a preliminary exam for both cases, so I sort of have a sense of what the problems are. But that wasn't why I got involved. I was asked to get involved because the prosecutor up there, arising out of just that one priest, announced the creation of a task force of law enforcement for the county of Saginaw, and in going to look into all sorts of concerns that they had about whether this is singular or not. And then they executed search warrants for employment records, but they made sure there was a TV crew with them. So it really was getting out of hand. And the bishop up there, who's suffering from cancer, his energy level was not what he would like it to be, and he wasn't responding perhaps as well as he could have. And so they asked if I would come up and take a fresh look at everything. Are we doing everything properly? And if so, then fine. If not, we want to fix things. Well, they are, from everything I can tell. They are doing all that they're supposed to do. They are reporting any incidents that come to them. Hopefully, the idea is to be able to give people a little peace of mind that they're doing a good job.
All right, we'll take one more break. We'll come back with a final segment. Talk a little bit your thoughts about the judiciary today and what's next in retirement. We'll be right back. Stay with us. Judiciary today and how you think maybe it's seen by the public, especially this tug of war between the political end and the judicial end.
You see it more, for interestingly enough, at the federal court level with President Trump in the last year or so, I believe, than you do, let's say, in Michigan. Our judges in Michigan have been calling the balls and strikes, I think, appropriately. They're doing the very best they can. I know a liberal Democrat colleague who would look at something and say, that's not where the law is, so I can't go there. I have to follow the law. Almost universally. Certainly on the Court of Appeals, that was the approach. I can't speak to the private deliberations of the Supreme Court, but I know that was true for our court.
Are there some judges here in Michigan that you would like to see nominated to the Supreme Court to fill the vacancy of Justice Kennedy, if you could make that appointment?
Yes, there are some, and some whose names have not necessarily surfaced. But I can tell you, and I'm not going to get in trouble by naming one or two and then forgetting the third one.
Okay.
But there are some wonderful judges on the Court of Appeals of Michigan, on the Sixth Circuit Court of Appeals, and certainly of our Michigan Supreme Court. They would do a great job. Just outstanding.
All right, don't want to give any names.
I don't want to get in trouble.
All right, we don't want to get you in trouble. Let's talk a little bit about this McConnell rule. I realize that that's on the federal level. It's certainly being debated right now whether or not an appointment to the Supreme Court should be made in an election year. Not a presidential election year, but it is a key election year where the balance of the Senate could change, and their role is advise and consent on whoever is nominated to the court.
Let's state the obvious. Since I'm retired now, I'm entitled to have an opinion on some things that I probably shouldn't otherwise. Whoever's got the votes wins the game. And right now, McConnell has got the votes, and all you need is a majority, and so of 51. So I think it's going to happen. But we need to go back. We need to go back into when Kennedy was appointed, go back into Bork, and when Judge Bork was first nominated.
And this thing has nominated by President Reagan.
And this thing has just deteriorated year after year after year. And one side says, well, this is the way they treated us, and now we're going to treat the other them the same way.
Tit for tat.
Back and forth over the last 30 plus years. Horrible. And just heartbreaking when you think about it, because it doesn't denigrate the individual, but it denigrates the office, I believe. And it's just a shame.
Should a president, Democrat, Republican, just whoever is serving at any given time, if they are charged with a crime, should they, or do you believe they can pardon themselves?
Of course not. No,
I
don't think you can, but I don't think they should.
So you think President Trump is wrong about it? He says that he believes he has the power to do it. He says he won't have to do it because he's done nothing wrong. But the fact that he feels, if I want to, I could. Do you agree with this?
The closest we ever came to an interesting constitutional crisis was under Nixon. And to Nixon's credit, to President Nixon's credit, he respected the rule of law. And when he had adverse rulings from the United States Supreme Court, he honored them, even if he disagreed. And you have to have a respect for the rule of law, and pardoning yourself denigrates that whole concept of rule of law to the point where we would do enormous damage to the institution of the presidency. I'm not even sure, quite frankly, that he could do it under the Constitution. But then you get into this fight, and you've got court rulings and so forth. If we ever got to that point, the president would just have to step aside.
And if we got to that point, it would surely probably go to the U.S. Supreme Court to make that final decision.
Of course it would.
All right.
Yeah.
What's next?
Well, I don't need a job.
But that's a nice thing to be able to say. Yeah.
Yeah, and
dues.
I would like. I'm in search of projects that have something that has a beginning and an end, where I can be useful. That's the whole reason we're on this earth, is to be useful. And so I want to keep doing that.
You're not ready to just go get a good book, sit in
I got one of those. I got a book on
comfortable chair and
listen,
just say,
I got a book on Ulysses Grant that's 1,000 pages. I'm into his second term. That's as far as I've gotten so far. So I'll do a little of that. And I want to go to school at least part of the year to higher ed colleges.
You're going to England?
I'm going to go to England. I'm going to study at Oxford for a few weeks. I want to always have something like that going on too.
Judge, thank you so
Thanks,
much.
Chuck.
It's been a pleasure.
I enjoyed it.
All right. And we want to thank you at home for joining us. I'm Chuck Stokes. We'll be back next week with more newsmakers in the spotlight. We hope you have a great week.